You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The Global Privacy Enforcement Network, often referred to as GPEN, was created to improve cooperation among privacy enforcement authorities around the world. Its objectives are broad but highly practical: to encourage communication, share best practices, and conduct joint actions where multiple regulators have common concerns. Membership includes data protection authorities from Europe, North America, Asia, Latin America, and Africa, making it one of the largest and most diverse collaborative networks in privacy. For learners, the significance of GPEN lies in the fact that no single regulator can effectively police global data flows alone. Personal information often moves instantly between jurisdictions, creating overlapping risks and obligations. On the exam, understanding GPEN requires recognizing its purpose as a voluntary coordination forum, not a treaty-based body with binding powers. Its value is in aligning enforcement direction, reducing duplication, and giving regulators tools to act in unison when privacy problems cross borders. GPEN's cooperation mechanisms include both sweeps and structured information sharing. Sweeps are coordinated reviews in which regulators around the world focus on a specific theme, such as mobile application permissions, website privacy notices, or children's online services. Each participating authority investigates organizations in its jurisdiction, and then the results are combined to create a global picture of compliance, strengths, and weaknesses. Structured information sharing, by contrast, enables authorities to exchange non-public insights about enforcement methods, trends, and priorities. These tools serve as an early warning system highlighting areas where companies may face heightened scrutiny. For exam candidates, the important detail is that sweeps are not enforcement in themselves, but often lead to deeper investigations or reforms. Recognizing how GPEN uses these cooperative tools shows how informal collaboration can shape compliance expectations across dozens of legal systems simultaneously. Cross-border investigation coordination is another essential feature of international enforcement. Without coordination, organizations might be subject to duplicative or even conflicting demands from regulators in different jurisdictions. GPEN and similar cooperative bodies help reduce that risk by enabling parallel proceedings to be managed in a harmonized way. For instance, when a multinational data breach occurs, European regulators may coordinate with U.S. agencies to align questions, evidence requests, and timelines. This improves efficiency while protecting due process for organizations under scrutiny. For exam purposes, the key lesson is that coordination does not eliminate independent enforcement authority. Rather, it creates a structured environment where regulators can share findings and reduce unnecessary overlap. Learners should be able to explain how cross-border coordination balances national sovereignty with the need for unified action against global privacy risks. Mutual legal assistance treaties, commonly referred to as MLATs, provide the more formal side of international evidence sharing. Unlike GPEN's voluntary exchanges, MLATs are treaty-based commitments that establish legal procedures for one country to request evidence from another. This is particularly important in criminal investigations, where due process protections require official channels. However, MLATs are often slow, bureaucratic, and subject to political considerations. For exam candidates, the key comparison is between GPEN's flexibility and MLAT's rigidity. GPEN facilitates quick coordination in regulatory matters, while MLATs are essential for transferring admissible evidence in prosecutions. Understanding these differences helps explain why regulators rely on a mix of informal cooperation and formal treaty pathways. On the exam, a scenario may describe investigators seeking data stored abroad and test whether GPEN or an MLAT would be the correct mechanism. International comity and conflict of laws principles further complicate cross-border enforcement. Comity is the idea that regulators and courts should respect the authority of other jurisdictions, even if they disagree on outcomes. For example, a U.S. regulator may temper its demands to avoid directly contradicting European privacy law, or vice versa. Conflict of laws questions arise when two countries impose contradictory obligations, such as requiring disclosure of data in one jurisdiction while prohibiting disclosure in another. For learners, the key takeaway is that comity is about cooperation and restraint, not about giving up authority. On the exam, scenarios may test whether regulators should pursue aggressive enforcement or defer to foreign counterparts. Recognizing comity ensures candidates understand how international enforcement balances assertiveness with respect for sovereignty, reducing unnecessary conflicts in an already complex legal environment. Data protection authorities, or DPAs, play central roles in international cooperation by working directly with U.S. regulators on cross-border cases. European DPAs, for example, often interact with the Federal Trade Commission or the Department of Commerce when issues arise under the GDPR or data transfer frameworks. These relationships allow for smoother handling of consumer complaints, faster resolution of disputes, and more consistent expectations for multinational organizations. For exam candidates, the key detail is that DPAs do not act as global regulators but as cooperative partners, linking their local authority with U.S. enforcement through shared mechanisms like GPEN. Scenarios may test recognition of how DPAs and U.S. agencies collaborate, reinforcing that privacy enforcement across borders is an ongoing dialogue rather than a rigid hierarchy. This illustrates how international cooperation strengthens consumer protection while maintaining national authority. U.S.-European Union supervisory cooperation represents one of the most important cross-border relationships in privacy. Given the volume of data flowing between these regions, regulators on both sides have established structured processes for communication, especially in consumer protection and data transfer contexts. The FTC, Department of Commerce, and European DPAs often coordinate on matters like complaints under the EU-US Data Privacy Framework or investigations into multinational technology companies. For exam candidates, the key concept is supervisory partnership. Regulators are not merging authority but working together to align expectations and ensure accountability. Scenarios may test whether a cross-border investigation requires EU-US cooperation or falls solely within U.S. jurisdiction. Understanding this relationship is crucial because transatlantic enforcement serves as a model for global collaboration, shaping how privacy law adapts to the realities of digital trade. Standardized transfer mechanisms such as standard contractual clauses and adequacy frameworks are more than compliance tools. They also serve as touchpoints for enforcement. Regulators frequently audit whether organizations relying on these mechanisms actually implement the safeguards they promise, such as encryption, limited access, or contractual oversight of vendors. For exam purposes, the key point is that SCCs and adequacy are not set-it-and-forget-it instruments. They require ongoing diligence and may trigger enforcement if violated. Scenarios may test whether an organization's reliance on SCCs or participation in the data privacy framework satisfies regulatory obligations. Recognizing this principle reinforces that transfer mechanisms are both legal and practical commitments, monitored by multiple regulators across jurisdictions to ensure personal data remains protected. Cross-border breach notification illustrates the difficulty of aligning regulatory requirements across jurisdictions. While the GDPR requires notice within 72 hours, U.S. state laws often allow longer periods, and other countries impose different triggers or formats. For multinational organizations, this creates a challenge. One incident may require dozens of different notices at different times, with conflicting content requirements. For exam candidates, the key terms are timing alignment and coordination. Scenarios may test whether an organization met breach obligations under both U.S. and EU frameworks simultaneously. Understanding these challenges highlights the complexity of cross-border compliance and the heightened enforcement risk that arises when organizations fail to harmonize responses. This reinforces the need for global incident response strategies, tailored to multi-jurisdiction requirements. International consumer protection and competition networks also intersect with privacy enforcement. Organizations such as the International Consumer Protection and Enforcement Network (ICPEN) and the Organization for Economic Cooperation and Development (OECD) promote collaboration across a broader spectrum of consumer rights, competition law, and digital trade. Privacy issues often overlap with consumer deception or unfair competition, creating opportunities for regulators outside traditional privacy authorities to become involved. For exam candidates, the key idea is breadth. Privacy enforcement does not occur in isolation but is part of wider global consumer protection efforts. Scenarios may test whether enforcement stems from privacy-specific authorities or broader consumer networks. Recognizing these relationships emphasizes the interdisciplinary character of privacy enforcement and the increasing integration of privacy into global consumer law. Data localization and government access laws add another dimension to cross-border enforcement challenges. Some countries require that personal data remain stored locally, limiting the ability of organizations to transfer information abroad. Others restrict compliance with foreign government requests, creating direct conflicts with U.S. or European demands. For learners, the key terms are localization and access restrictions. On the exam, scenarios may test whether U.S. regulators can obtain data stored in a country with strict localization rules. Understanding these conflicts reinforces the principle that global compliance often requires balancing competing obligations, where satisfying one regulator may violate another's laws. This complexity underscores why cooperative frameworks like GPEN are essential for practical enforcement. The history of safe harbor and adequacy arrangements highlights the evolution of cross-border frameworks. From the original Safe Harbor Agreement, which was invalidated, to the Privacy Shield, and now the EU-US Data Privacy Framework, each system illustrates the tension between US and EU approaches to privacy. Legal challenges, particularly the Schrems cases, have forced renegotiation and adaptation of transfer mechanisms. For exam candidates, the key idea is evolution. Adequacy frameworks are not static but shift in response to judicial and regulatory scrutiny. Scenarios may test whether organizations relying on outdated frameworks remain compliant. Recognizing this evolution underscores the importance of staying current with cross-border legal developments, as frameworks directly shape both compliance strategies and enforcement risks. International organizations provide further guidance on cross-border practices. The OECD, Asia-Pacific Economic Cooperation (APEC), and the United Nations issue principles, model laws, and best practice frameworks that, while not legally binding, heavily influence national regulators. These initiatives promote harmonization and reduce fragmentation, making it easier for organizations to comply with multiple regimes. For exam purposes, the key concept is persuasive guidance. Scenarios may test whether compliance with international recommendations satisfies national regulators. Recognizing this influence highlights how privacy norms are shaped not only by law, but also by global consensus, which informs enforcement priorities across jurisdictions. Transparency and due process are critical principles in cross-border enforcement. Regulators must ensure that organizations receive fair notice of allegations, opportunities to respond, and protection against arbitrary demands. This is especially important when multiple authorities are involved, as procedural fairness can vary significantly across jurisdictions. For learners, the key terms are fairness and accountability. On the exam, scenarios may test whether an international investigation respected due process. Understanding this principle underscores that enforcement is not only about authority, but also about legitimacy, ensuring that privacy protections align with fundamental rights in a global enforcement context. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. GPEN's annual sweeps are one of its most visible tools for evaluating global privacy practices. During these sweeps, regulators from dozens of jurisdictions examine a common theme, such as how websites present privacy notices, whether mobile apps request permissions transparently, or how organizations handle children's data. The strength of sweeps lies in their ability to reveal systemic issues across multiple countries at once, highlighting patterns of weak compliance or misleading practices that might otherwise go unnoticed. Importantly, sweeps are not enforcement actions themselves, they are diagnostic and educational. However, the findings frequently trigger follow-up investigations or targeted enforcement by national regulators. For exam candidates, sweeps illustrate how GPEN translates cooperative dialogue into real-world accountability. Scenarios may test whether sweeps impose penalties directly or function as coordinated reviews that lead to later action. Recognizing this distinction shows how soft oversight mechanisms evolve into harder enforcement tools. Data brokerage and advertising technology have emerged as priority areas for cross-border enforcement. These industries often involve complex chains of data transfers, profiling, and targeting that span multiple countries without direct relationships to the individuals affected. Regulators view these practices as high risk because they are opaque and can undermine consumer autonomy. International cooperation helps address the reality that a single company might operate data systems in dozens of jurisdictions simultaneously. Through GPEN sweeps and joint investigations, regulators share strategies for demanding transparency and accountability from brokers and ad tech networks. For learners, the key terms are profiling and opacity. On the exam, scenarios may test whether ad tech practices fall under cross-border scrutiny. Understanding this focus reinforces that industries most reliant on global data flows and least transparent about their operations are particularly vulnerable to international cooperation and enforcement. Biometric technologies, artificial intelligence, and automated decision-making are also at the forefront of global privacy enforcement. Regulators worldwide are converging on concerns that these tools can create disproportionate risks, such as discriminatory outcomes, over-surveillance, or erosion of autonomy. GPEN members have shared insights into regulating facial recognition, predictive analytics, and algorithmic scoring, seeking harmonized approaches to transparency, fairness, and accountability. For exam candidates, the key terms are bias and fairness. Scenarios may test whether organizations deploying AI in hiring or lending have satisfied international expectations for oversight. Recognizing these global themes highlights that privacy enforcement is no longer only about data collection and storage. It now encompasses the fairness and ethics of decisions made with personal data. This broader scope reflects the growing overlap between privacy, human rights, and technology regulation worldwide. Examples of coordinated action across regulators demonstrate the power of international cooperation. Joint investigations have targeted companies that overstated their data deletion practices, misrepresented encryption claims, or tracked children's online activities without appropriate consent. In such cases, regulators in multiple countries aligned their findings and remedies, ensuring that outcomes applied consistently across borders. For learners, the key takeaway is that enforcement can scale globally even without a single supranational authority. Exam scenarios may test whether an enforcement outcome stems from domestic action or coordinated international proceedings. Recognizing coordinated enforcement emphasizes that global companies cannot resolve privacy issues by negotiating with one regulator alone. Cooperation ensures accountability across multiple jurisdictions simultaneously. Corporate group structures create additional complexity in international enforcement. A parent company might centralize data processing functions in one country, while subsidiaries operate across many others. Regulators must decide whether liability attaches to the local entity, the parent, or the entire corporate group. Shared service models, common in cloud and technology industries, complicate this further by blurring lines of responsibility. For exam purposes, the key concept is accountability allocation. Scenarios may test whether liability falls on the parent company directing global operations or the subsidiary conducting local processing. Understanding this complexity highlights the importance of governance structures, that clearly document roles and responsibilities within multinational groups, ensuring that regulators can trace accountability for privacy compliance across corporate boundaries. Parallel tracks of enforcement often arise when incidents cross borders. A single large-scale breach might trigger administrative investigations in Europe, civil lawsuits in U.S. courts, and even criminal prosecutions in another jurisdiction if fraud or intentional misconduct is involved. These overlapping processes require organizations to manage risk on multiple fronts, each with its own remedies and timelines. For exam candidates, the key term is multiplicity. Scenarios may test whether a settlement in one jurisdiction resolves liability everywhere, or whether parallel actions continue. Recognizing that cross-border incidents rarely conclude with a single proceeding reinforces the idea that privacy compliance must anticipate layered enforcement, requiring global incident response strategies aligned to diverse legal systems. Attorney-client privilege and professional secrecy create further challenges in cross-border investigations. Legal protections that shield communications between lawyers and clients in the United States may not hold in other countries, where regulators can demand broader disclosure. Similarly, professional secrecy rules protecting auditors or compliance officers may vary significantly. For learners, the key terms are privilege and secrecy. On the exam, scenarios may test whether organizations can withhold documents in cross-border enforcement proceedings. Understanding these differences highlights why international investigations are fraught with uncertainty, and why organizations must adapt legal strategies to diverse national rules while still maintaining compliance and cooperation. Cross-border e-discovery adds another layer of complexity, especially when litigation in one jurisdiction requires transferring large amounts of data from another. U.S. courts often demand comprehensive discovery, while European and Asian privacy laws restrict the export of personal information. Organizations must reconcile these conflicting requirements by using minimization, anonymization, or redaction before transferring data. For exam purposes, the key concept is reconciliation. Scenarios may test whether a company balanced discovery obligations with foreign privacy restrictions. Recognizing this principle illustrates how privacy law intersects with civil procedure, requiring creative solutions to honor both litigation duties and cross-border data protection rules simultaneously. Standard contractual clauses remain one of the most common mechanisms for cross-border data transfers, but they are also frequent enforcement targets. Regulators may audit whether companies using SCCs have actually implemented the supplementary safeguards they promised, such as encryption or monitoring government access. Following the Schrems decisions, compliance with SCCs is not just a matter of signing documents. It requires ongoing diligence and operational proof. For learners, the key term is enforceability. Exam scenarios may test whether reliance on SCCs without supplementary safeguards meets legal standards. Recognizing this issue reinforces that transfer tools are subject to scrutiny and that regulators across jurisdictions are aligned in demanding more than paper commitments. The EU-US Data Privacy Framework, which replaced the Privacy Shield, illustrates how cross-border participation creates direct enforcement implications. Companies that certify under the framework commit to Department of Commerce oversight and FTC enforcement in the United States while gaining adequacy recognition in the EU. This dual accountability ensures that commitments made under the framework are legally binding in multiple jurisdictions. For exam candidates, the key terms are certification and dual enforcement. Scenarios may test whether participation provides adequacy coverage and whether violations trigger both U.S. and EU scrutiny. Recognizing these implications highlights how participation in international frameworks extends obligations beyond borders, requiring consistent adherence to commitments. Binding corporate rules offer another pathway for cross-border compliance, particularly for multinational groups. BCRs are internal codes approved by regulators that allow data transfers within a corporate family under strict safeguards. Once approved, they create enforceable obligations across all participating entities. Regulators expect ongoing audits, transparency, and accountability from organizations with BCRs. For exam purposes, the key term is internal adequacy. Scenarios may test whether BCRs require regulator approval and continued oversight. Recognizing this mechanism highlights how large companies formalize internal governance into legally enforceable commitments that satisfy regulators across borders, providing both flexibility and accountability. A risk-based approach is increasingly central to international enforcement expectations. Regulators acknowledge that organizations face varied risks depending on the sensitivity of data, the scale of processing, and the context of operations. Demonstrating that risks have been assessed, documented, and mitigated shows diligence and good faith. For exam candidates, the key term is articulation. Organizations must explain their reasoning clearly to satisfy different regulators. Scenarios may test whether a company adopted a proportionate response to identified risks. Recognizing this trend highlights that compliance is not only about following rigid rules but also about showing thoughtful, documented stewardship across diverse regulatory environments. Incident response playbooks must be adapted to meet multi-jurisdiction triggers. A single breach may require compliance with U.S. state breach notification laws, GDPR obligations, and APAC reporting requirements, all on different timelines. Effective playbooks map these obligations in advance and include protocols for coordinating disclosures across borders. For learners, the key concepts are harmonization and anticipation. Exam scenarios may test whether an organization's incident plan adequately addressed both domestic and foreign laws. Recognizing this principle reinforces that privacy readiness requires global perspective. Organizations cannot afford to focus narrowly on one jurisdiction when personal data is inherently transnational. Finally, governance recommendations for global compliance monitoring emphasize the need for ongoing oversight across jurisdictions. Organizations with international operations must track legal changes, maintain compliance dashboards, and ensure that board-level reporting includes global privacy risks. Regulators increasingly expect multinational enterprises to prove that compliance is continuous, coordinated, and responsive to emerging issues. For exam purposes, the key concept is continuous governance. Scenarios may test whether monitoring systems were global or limited to local operations. Recognizing this requirement illustrates how privacy governance has matured into an enterprise-wide responsibility, where accountability is measured not only by adherence to law, but by demonstrable, sustained oversight in a global enforcement environment. By mastering GPEN's role, international cooperation mechanisms, and cross-border enforcement practices, candidates gain insight into the future of privacy governance. Enforcement today is inherently global, requiring organizations to satisfy regulators across multiple jurisdictions simultaneously. GPEN provides the collaborative infrastructure, while frameworks such as SCCs, BCRs, and the Data Privacy Framework create the legal mechanisms. For exam success, the key is understanding how these tools operate together to balance sovereignty, accountability, and practical cooperation in protecting personal data worldwide. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.